All right. Good afternoon. Could everyone hear me?
Yes, I can hear you.
All right, perfect. So we're going to start. It is 1 p.m., July 25th. Thank you all for joining this webinar. It will begin shortly, and shortly is now. My name is Damon Brathwaite. I am filling in for Shaina, who normally runs the webinars. Now, just a little bit about PSS. Well, today the legal planning key documents for caregivers is going to be presented by Britt Burner. Britt Burner from Law Group PC, Elder Law, Trust and Estates, Special Needs Planning. A little bit about PSS is that PSS was founded in 1962. It is an innovative multi-service agency whose mission is to strengthen the capacity of older New Yorkers, their families, and the communities to thrive. Our educational and other programs online at our 9 local centers and other locations are designed to help older adults stay healthy, engaged, and connected. The services of PSS Circle of Care ensure that those caring for someone who is frail, chronically ill, or has memory loss are not alone. We also serve kinship caregivers, both young and old. Our coming of age program inspires people 50 plus to live with passion and purpose. Thank you for participating. To learn more about PSS Circle of Care, free support for family caregivers, you could visit psscaregivers.org. To learn more about coming of age for those 50 plus to live with passion and purpose, you could visit comingofage.org. All of our information, presentations, workshops, and events, you can visit pssusa.org/events/. Now, for all questions, all Q&A questions will be, you are free to actually ask those questions at the end of the presentation by Ms. Burner. Now, Ms. Burner, you're able to share your screen and begin. Thank you.
Thank you very much. Can you hear me okay?
Yes.
Okay, good. I just want to check that. All right, I'm going to switch the screen.
Okay.
Okay, so hi, everybody. My name is Britt Burner. I am an elder law and estate planning attorney. Our firm has offices in Manhattan, where I work, as well as out on Long Island on the East End, Suffolk County. And this is the only work we do. And we generally help people of all ages, their 20s all the way up until I think my oldest client to date's been 105 years old, with handling, making sure they're taken care of while they're alive and after death. And so today, we're going to talk about legal planning, key documents for caregivers of older adults. These are the topics that we're going to be discussing today: advanced directives, power of attorney, last will and testament, and trusts. Advanced directives. So this is a term that we use to refer to documents regarding your health care that you sign in advance of needing them, or if you're a caregiver, that the loved one that you're caring for signs in advance of needing them. The idea is that if you lose your capacity at some point in your life, your mental capacity to make decisions, that your wishes are known and that there are people in place to make those decisions for you. The first document that we are going to discuss is the healthcare proxy. The healthcare proxy requires that you be incapacitated. So what does that mean? That means that the document states who will make medical decisions for you if you are deemed incapacitated by a doctor. So if we'll use mom and daughter as an example. If mom goes to the doctor and is perfectly well mentally, she has full capacity, and the daughter calls the doctor afterwards and says, I would like to know what happened at my mom's doctor's visit, and the doctor says, I can't give you that information because your mom has health care rights of privacy, then the daughter cannot say, well, I'm the health care proxy, because mom is not incapacitated. So the daughter's ability to act and receive information as health care proxy has not yet been activated by mom's incapacity or being deemed so by a doctor. We suggest that everybody choose their initial agent or their agent to act on their behalf under the proxy, and also at least one successor agent. It is important to state who it will be and who will be the backup in case that person is unwilling, unable, or unavailable to act. When you sign a healthcare proxy, you need 2 witnesses over the age of 18. You do not need a notary to sign this document. You only need 2 disinterested witnesses. So if you are naming your daughter as healthcare agent, your daughter should not then be a witness to the document. I personally went into the hospital for a surgery, and I believe that they pulled over a nurse's aide and one of the janitors, and they witnessed my healthcare proxy, so that it was clear that while I was under anesthesia, while not a long-term incapacity, I had a brief incapacity, which is one in which I was not able to state my wishes if it was necessary to the doctors. It was very clear who I wanted to make those decisions for me. If you do not have a health care proxy and you're in a hospital or a nursing facility, there's something called the Family Health Care Decisions Act. This is a law that says who will be your surrogate decision maker, meaning who will be able to make decisions for you if you cannot make them for yourself. If you have someone named as healthcare agent under the healthcare proxy, that person takes precedence. If you do not have a healthcare proxy, it would be your spouse that could make decisions. If your spouse is, you don't have a spouse or they're unable to act, then it's your children. And the list continues on as to varying levels of closeness to you as to who can make those decisions. If you have 3 children and they all disagree on what should be done and you don't have a healthcare proxy, it is not clear to the doctors who is the person they should be listening to in terms of making the decisions. The healthcare proxy can include end-of-life decisions. The New York State Healthcare Proxy form on the first page at number 4 says, I direct my healthcare agent to make healthcare decisions according to my wishes and limitations, as he or she knows or as stated below. It is very important that the person naming another person to make medical decisions for them actually tells that person what kind of decisions they might want them to make. Because I can name someone to act for me, but I want to know that person would be doing and making the decisions that I would be making if I were able to speak up and state what I wanted. If you do want your agent to be able to make end-of-life decisions, including the giving or stopping artificial nutrition and hydration, then on number 4 in that state healthcare proxy form, you actually need to write in that your agent knows your wishes regarding artificial nutrition and hydration and can make those decisions on your behalf. You can also state on your healthcare proxy if you choose to be an organ and or tissue donor, and you can actually limit the organs that are used or the situations in which they're used, and that's something that can be filled in. Each of your 2 witnesses will date, print their name, sign, and put their address. A living will is a document that gives information to your surrogate decision maker as to what kind of decisions you would want them to make on your behalf. It talks about extraordinary measures, so as I was saying, to withhold or withdraw treatment. Very typically, we'll have clients sign living wills that say if I'm in an irreversible state with no hope of recovery, that I would not want my agent to give certain types of treatments to me. Certain treatments that are often listed on this document are cardiac resuscitation, mechanical respiration, artificial nutrition and hydration, antibiotics, blood and blood products, kidney dialysis, surgery or invasive diagnostic techniques. So you are putting into this document what kind of things you would want your agent to allow and what kind of things you would want your agent to withhold. It is very important that your living will state that your agent has the right to make those decisions. The potential treatments are the ones that I listed, and you could list any others that might be relevant in your situation. The living will also often refers to a desire to remain in your home if it does not cause an undue financial or other burden on your family or caregivers. As caregivers, the people on this webinar likely know that it is often wonderful to keep people at home, but there does sometimes become a medical or financial reason why they cannot remain in the home anymore while being treated, in which case the document would allow for them to be moved to a proper facility. Next, we're going to talk about the HIPAA waiver form. HIPAA is the law, the federal law, that says that you have information privacy for anything medical. So when you go to the doctor and you have a conversation with your doctor, that is privileged information that cannot be shared by the doctor with others without your consent. There is a New York State Department of Health form that you sign. It does not require a witness. You sign and date it. You will say to whom the records can be released and who should be releasing them. You can limit what records are released and the duration of time. So, for example, you might state that the hospital that you were recently seen at can release information to your daughter. That information can be unlimited in amount, or could say just things related to my blood work, for example. And then you can say the duration. This waiver is in effect until X date, December 31st of 2019, for example. Or you can state that it's in effect for an unlimited duration. And this has to do with the release of information. Again, this is important that unlike the healthcare proxy, which says that the daughter who was calling the doctor's office could only get information if mom was incapacitated, otherwise the document was not in effect, this HIPAA waiver form does not require that mom be incapacitated for the daughter to get that information. So in that situation, if the mom asked the daughter and said, can you please call the doctor and ask the doctor because I was a little confused about some of the things that were said and I want your opinion, the mother could have filled out a HIPAA authorization form where the daughter it's clear to the doctor that the doctor can release that information to the daughter in order to help mom make any necessary decisions. Next, we're going to talk about the MOLST form and the DNR form. These are actually doctor's orders. So unlike the prior documents that the healthcare proxy and living will, which only need 2 witnesses over the age of 18 who are unrelated to the situation, or the authorization for HIPAA release, which does not require any witnesses, the MOLST and the DNR form are ones that are ordered by the doctor and signed by the doctor. DNR is do not resuscitate. This is only talking about cardiopulmonary resuscitation. This is not talking about the other list of conditions that I was discussing. So while your healthcare agent, pursuant to your instructions or pursuant to your living will, may be able to tell the doctor, yes, this person would want a DNR signed because they do not want to be resuscitated, those other documents go beyond the DNR to the other items that I listed. A DNR is of limited duration. If you go to a hospital, when you are admitted, they ask if you are if you or the caregiver, they will ask the healthcare agent, is this person DNR, DNI? Do not resuscitate, do not intubate. If you say yes, they are DNR, DNI, those orders are signed and put into the person's chart for that hospital stay. However, if they go home and are readmitted, the question will be asked again, and the order needs to be redone by the doctor. It does not last forever, unlike the other documents that you're signing. Remember, we call them advance directives in advance of needing them. The MOLST form has to do with life-sustaining treatment. This is typically a form that is, it is a hot pink form. It is supplied by the state. It is most often for those who want to avoid life-sustaining treatment, for those who reside in a long-term care facility, or for those who may die within 1 year. This has to do with all of the items that somebody would want a doctor or EMT, if they were at home, to know. The original hot pink form is not only signed by the patient, but is also signed, or the patient or their surrogate, their healthcare agent or other. It is also signed by a doctor or nurse practitioner who presumably has gone through the form and discussed all the options. Medicare will pay for the MOLST form, for an appointment for the MOLST form to be completed. It is not a physical that they're paying for. It is just for the consultation with the doctor to review and sign the document. It has to do with cardiopulmonary resuscitation. It asks if the person has signed the advance directives, healthcare proxy, living will, information about organ donation. It talks about different treatment guidelines, whether you would like comfort measures only, limited medical intervention, or no interventions at all. It talks about intubation, mechanical ventilation, transfer to the hospital. Some people choose to live out their days at home with hospice care as opposed to being treated in a hospital if they are at end of life. It talks about feeding tubes, IV fluids, the amount of time for each of those that it would be administered, antibiotics, etc. So it covers, a lot of these you'll find are pretty redundant. They cover the same items. But again, this MOLST form is done for somebody who is towards the end of life, who has a specific diagnosis, there is an expectation amongst the doctors that they may not live within for an entire year, and they're choosing to avoid the life-sustaining treatment. That's often who will fill out this MOLST form. So many of our younger clients are doing the healthcare proxy and the living will only for the MOLST form to be filled out much later in life. The next item is the power of attorney. The power of attorney, many people hear the word durable. What does durable mean? A durable power of attorney is one that lasts throughout incapacity. So what that means is if you sign a power of attorney now, it is in effect when you sign it, and it is also in effect after you become incapacitated. The current New York State Power of Attorney form does not have the word durable in its title. However, the terms of it state that unless the document says it is not durable, all New York State powers of attorney are deemed to be durable. Unlike that healthcare proxy where the daughter cannot act on mom's behalf unless mom's incapacitated, this power of attorney is in effect as soon as you sign it. A person who signs a power of attorney needs to sign in front of a notary. Then the person they are naming to act on their behalf, who we refer to as their agent, will also sign the document in front of a power of attorney, agreeing to assume the responsibilities. Often clients will sign a power of attorney themselves and don't yet feel comfortable with someone else having access to their bank accounts, being able to sell their property, access their safe deposit box, or do anything else in regards to their financial life. If that's the case, Sometimes clients will sign in front of a notary and the document is activated. However, the document cannot be used by the person named as agent until that agent signs in front of a notary and brings the document to the necessary place. For example, if I have a checking account and I've named someone as agent and I don't want them to access that checking account right now, I may sign the document, have it notarized, put it away, and if I become incapacitated, that person can take the document, have it notarized, and bring it to the bank so that it can be put on the file so that it's known to the bank that this person can act as the agent on that account. Without putting it on file with the bank, that person cannot act as agent for me. The responsibilities of the agent depend on how the document is written. The agent only has the powers which are granted in the specific document that is signed. Many people have a power of attorney where there are standard powers and they are titled A through P, and if you initial letter O, it gives all of the above stated powers. However, there's an additional section called the modifications section, which allows the drafter of the document to add in additional powers that might be necessary. As an elder law attorney, we are often adding in powers in that section that refer to things that come up in the process of applying for Medicaid services for home care or nursing home care. This can include all sorts of forms that need to be signed on behalf of the Medicaid applicant, as well as information access for things that need to be gathered for the Medicaid application. The document also has something called a statutory gifts rider. So the power of attorney document is signed and notarized. The agent, again, signs and has it notarized. And then the person signing the document can decide if they want to sign a statutory gifts rider. It is an addendum to the power of attorney. It must be signed at the same time as the power of attorney, and it allows what we call gifts. New York State uses a very wide definition of the term gifts. It has to do with any transfer of assets out of the name of the, we call them the principal, the person who's giving the power of attorney away. And it's anything that goes from that person's name to someone else's name. This could be from the creator of the document to a trust, be from the creator of the document to their children, from the creator of the document to the agent being named, from the creator to a charity. Any transfer of assets out of the person's name requires the statutory gifts rider. Again, this is a very important part of the document, especially if the person being named is going to assist with Medicaid planning. If you are at home on Medicaid receiving long-term care services with a home health aide, any excess income, meaning income over $879 per month, that's the number determined by the state, any income over that amount per month needs to go into a special account called a pooled income trust and then can be used to pay the bills of the Medicaid recipient. However, the Medicaid department has taken the position that without the statutory gifts rider specifically allowing for this monthly transfer of income, then it cannot be done. So this is a very important power to have in the power of attorney document. One thing I didn't say about naming an agent is that you can name more than one agent to act. If you have two children, you can name both children. You can require that they do everything together, or you can allow them to act separately. Beyond that, you can name successor agents. Again, one person to act alone or two people to act either together or separately. The statutory gifts rider, in addition to being signed by the person giving the power of attorney and being notarized, requires a second witness. So there are two witnesses to the statutory gifts rider. One person can be the notary and then a second witness as well. Again, the witness needs to be over the age of 18, and not be the person being gifted the authority to act. They will put their signature as well as their address on the document. Next, we're going to discuss the last will and testament. A last will and testament is a document that says how you want your assets to be distributed at the time of your death, to whom and in what way, and who will be in charge of doing that. The executor is the person who you are nominating in your last will and testament document to act on behalf of your wishes. That executor will make the distributions based on what your document says. A specific bequest is giving a certain item or a certain amount of money to a person or charity. For example, I give my diamond ring to my cousin, or I give $3,000 to my cousin. These are specific bequests and come off of the top of the estate before anything else is paid out. After the specific bequests are paid out, there is the residuary to be paid out. The residuary in most last will and testaments will be defined in either shares or percentages. For example, I have 3 children and they each get 1 share, 1 equal share, meaning my residuary estate, anything left after the specific bequest, would be divided by 3 and they would each get a share. You can also state percentages. You could give X percent, 20% to a charity, and then divide the other 80% amongst your friends and family as you decide. The remote contingent article is the part of the will that says if all of the persons that I have named in my residuary have predeceased me and are not living at the time that my will is distributed, then this is who should be the taker of last resort. Very often a will say that if all of my beneficiaries have not been or have predeceased me, then the remote contingent may be a charity, or it may state that whoever the state of New York deems to be my next of kin. After death, a last will and testament must go through the probate process. A last will and testament without the probate process is merely a statement of your wishes. The probate process, when does a will go through probate? A will goes through probate any time a person dies with assets in their sole name with no beneficiary. If you own your apartment, but you have a bank account that is joint with your spouse, or let's go back to mother and daughter. You own your mom owns the apartment in her own name. There's a checking account that's joint with her daughter, and there's an IRA or other retirement account that names her daughter as beneficiary. Then the bank account will go to the daughter as joint owner. The retirement account will go to the daughter as beneficiary, but the apartment will cause the will to go through the probate process because it is in mom's sole name with no beneficiary, meaning that the co-op organization, the management, does not have information about who is the rightful owner of that co-op after mom's death, and they will not have that information until the process of probate is completed. The purpose of the process of probate is to make sure that mom's wishes are followed and that those persons that mom has named to receive the apartment get their share. The real purpose of probate is also to show that mom's will is valid, that her signature was not forged, she did not sign it as a result of undue influence, or because she was forced in any manner. When the probate process is underway, it requires that notice be given to certain persons that your will is going through this process. the state of New York determines who your next of kin is, and that is who is entitled to receive notice. If mom has a spouse and children, well, then the spouse and children are entitled to receive notice that the will is being probated. This also gives them an opportunity to come in and contest if they have anything to say about the validity of the will. If you do not have a spouse or children, your next of kin are your parents. If your parents are deceased, your next of kin are your siblings. If your siblings are deceased, your next of kin are your siblings' children. It goes down that bloodline. If you were an only child and you had no siblings, then the next of kin would be your first cousins, so on and so forth. So then we get to when to avoid probate. There are three main situations in which you would avoid probate. The first is if you are disinheriting one of these next of kin. If mom has a son and a daughter and is choosing to disinherit her son from her will, and he is entitled to notice based on what we just said, then it's very possible that mom will not want him to get notice because he can come in and contest the will, be a nuisance to his sister, maybe rightly so, or perhaps if not rightly so, just to get a payoff from the estate where he was otherwise to get nothing. So if mom is disinheriting one of her children, one of her natural heirs, she would want to avoid the probate process. The second time you might want to avoid the probate process is if your beneficiary is disabled and can't represent themselves in the probate proceeding. In that case, often the court will appoint somebody, a lawyer, to represent that person, and that can get costly. While it is appropriate in certain situations, in some situations it's just a cost that many want to avoid. The other time you want to, there are actually 4 times you want to avoid probate. So the third time is when you have property in multiple states. If you are a New York resident and you are rent controlled here in New York, but you own a property up in Massachusetts and maybe perhaps a condo down in Florida, your will would have to be probated in all 3 states. First, a probate here in New York as your primary residence, and then what we call an ancillary probate in Massachusetts and in Florida. Many want to avoid the duplicative proceedings. The fourth time you want to avoid probate goes back to the issue of those entitled to notice. If you do not have a family where those entitled to probate are obvious, then you would likely want to avoid the probate process. For example, we had a client who, he was not a client while he was alive, but after his death, he had 2 friends who were named as co-executors and were to receive 50-50 distribution of the residuary of his estate. And they came to see us to probate his will, and we started asking all of these questions. Who is his next of kin? Well, this gentleman was unmarried without children. His parents were deceased. He had no siblings. Presumably his next of kin is somewhere in the cousin level, but he did not have a close family. His parents came to this country, one from Egypt, the other from France. It was after the war. They don't know where the family dispersed to. The probate of his will ended up being a very timely, time-consuming and expensive process because the court requires that we attempt to find whoever is his next of kin, and then that we notify them and give them an opportunity to come in and to say something about it. And if we can't find them, we have to publish in certain newspapers to try and notify them. So you may have heard of someone who got a call that some long-lost cousin they didn't know existed, that they're receiving some portion of their will. This is sometimes why. You'll also see in the back of a newspaper the short paragraph death notices. These are actually in there as a requirement of the court in order for a certain will or a certain estate to be administered. If you do not have a will, you go through a process called administration. The administration process is very similar to the probate process, the difference being that those persons who are deemed to be your next of kin will actually also receive the disposition of your assets. They will receive them as beneficiaries in addition to just getting notice. So if you're looking to change the persons who receive your assets, or looking to name charities or name anyone other than who the state determines to be your natural next of kin, then you would want to make sure that you have documents completed that state so, because otherwise the default would be whomever they determine to be your next of kin. So then the question becomes, how do you avoid probate? One way to avoid probate is a trust. We'll get to that in 1 second. I quickly want to talk about the other ways to avoid probate. Probate can otherwise be avoided, as I said, by naming a joint owner on an asset or by naming a beneficiary. So a joint owner on a bank account, a beneficiary on a bank account. These will all avoid the probate process. If you say that my Chase checking account goes to my daughter in your will, but on the actual account you name your son as a joint owner, then it doesn't matter that the will says it goes to your daughter. Your son will take because it is his as a matter of right, because the designation on the account will override the last will and testament. Another way to avoid probate is by having a trust. A trust is a living, breathing entity, the rules of which are written in a trust document. For example, when you decide to create a trust, you would meet with a lawyer and you would end up signing a trust document that says who you are, that you're putting assets into this trust. It would have all of the terms, and there's many different types of trusts, but the terms and how the trust operates and what the trust accomplishes are going to depend on what terms are put into the trust. The trust will say how the assets are to be treated while you were alive, and then it will say what happens with the assets upon your death. I said before that anything that goes through probate is because it's in your sole name with no beneficiary. But if you have a bank account in your name and you then create a trust and you change the name on the bank account to be the trust's bank account, so my name is Britt Burner, instead of it being Britt Burner's checking account, it's the Britt Burner Trust checking account, well, that is no longer in my sole name, and therefore it avoids probate. A revocable trust is created for that exact purpose. It is revocable. It is amendable. You can change it. You can be your own trustee. You can move assets in and out as you see fit. You can do whatever you want with those assets. The main purpose, and really the only purpose that most people do a revocable trust, is if they're trying to avoid probate. Remember, we talked about avoiding probate because of the notice requirements or because of a disabled beneficiary, and so that is why many people would create a revocable trust. There's also many types of irrevocable trusts. Some people do irrevocable trusts for tax planning. That's less and less these days because there are very high tax exemptions, meaning very few people end up dying with enough money in their name that taxes are generated as a result. I have very few clients who end up having estate taxes owed because in New York State, if you have less than $5.74 million, you do not have estate taxes owed at your death. This is very good news for your beneficiaries. I do have many clients who do irrevocable trusts and a specific type of irrevocable trust for Medicaid asset protection planning. This is a trust in which, if we use the mother-daughter scenario again, mom is the creator or the grantor, sometimes known as the settlor of the trust, and she can name her daughter or any person other than her or her mom or her spouse can be the trustee, meaning they manage the assets that are put into the trust. Again, the trust can be written to suit mom's needs, but in order for the assets in the trust to not be counted as mom's asset for Medicaid eligibility, the document needs to state that mom cannot receive distributions of principal. However, the document can state that mom receives income. I'll give an example. If mom lives in that rent-controlled apartment in New York and needs nursing, home care, Medicaid, in that apartment in New York, and she puts that house in Massachusetts into the irrevocable trust, that is a piece of property that is then moved out of her name and it isn't counted as her asset for Medicaid purposes. If mom rents out that house, any income derived after payment of expenses will be mom's income, even though the house is owned by the trust. If then that home is sold within the trust and the money is invested, let's say the house sells for $150,000, there's a $150,000 investment account then in the trust. The principal, the $150,000, cannot be used for mom's benefit. Otherwise, Medicaid would say, if we're spending the money on mom, then we might as well spend the money on the things that Medicaid's going to pay for mom. So it's important that she not be able to use that principal. However, any interest or dividends earned on those investments can be considered income to mom and can go to mom to help pay her bills. Upon mom's death, the trust will state how the assets are to be distributed, just as she would in a last will and testament. Instead of having an executor, the trustee would act and have those same powers to collect all of mom's assets together and distribute them according to mom's wishes. Another type of trust is a supplemental needs trust. This is a trust that is created to supplement, not supplant, government benefits. For example, if somebody is on SSI and receiving income through SSI because they do not have any income of their own, they can have a supplemental needs trust that pays for additional items for them. SSI is meant to pay for food and shelter. If the supplemental needs trustee distributes to that beneficiary for food or shelter, there will be a reduction in their SSI benefits. However, if the beneficiary is on Medicaid, which is a health insurance program, and the supplemental needs trust needs to pay, for example, rent, that will not affect their Medicaid benefits. The assets in the trust will not be deemed theirs for the purposes of Medicaid, and they can have their housing paid for by the trust. A first-party supplemental needs trust is a trust in which the person who is on the government benefits takes their own money and transfers it into a trust for their own benefit. This type of trust requires a payback to the Medicaid program. We see these very often with beneficiaries of government benefits who perhaps were injured in an accident. Say someone's in a car accident and they receive a $100,000 personal injury settlement. They will often take that settlement and put it in a supplemental needs trust. They can continue to receive Medicaid or other government benefits to help care for them, but the supplemental needs trust money can be used to, again, supplement those government benefits. However, upon their death, since it is money that was their own that they put into a trust, the Medicaid program can be paid back for expenses paid before any other estate beneficiaries are paid. A third-party supplemental needs trust is a trust that is created by someone else for the government benefit beneficiary. For example, if somebody is in a car accident, but then their mother passes away and leaves them money in a supplemental needs trust, so it never touches their hands. It goes directly from mom's estate to a trust that mom created as part of her estate plan. That's called a third-party trust because a third party gave you the money. The money goes into the third-party trust. It can be used in the same way to supplement the government benefits the person is receiving. But the difference is upon that person's death, for in our mother-daughter example, if mom passes away and leaves the assets to daughter in a third-party supplemental needs trust, someone other than the daughter would need to be her trustee, but then upon the daughter's subsequent death, mom's documents would have stated where the assets are then distributed, perhaps to the daughter's children, perhaps to mom's other children, whatever it may be. A pooled trust is another type of supplemental needs trust that is created and is under federal law created by, run by, administered by a charity. Most often we see them as pooled income trusts. I alluded to this before when I spoke about excess income for someone who's on home care Medicaid. If somebody is receiving home care Medicaid benefits, I'll repeat, and has more than $879 a month in income, that could be their Social Security, it could be income from their Irrevocable Trust, pensions, required minimum distributions from retirement accounts, then that excess amount over the $879 will go into the pooled income trust, and then that money can be used to pay the bills of the Medicaid recipient. At the time of that person's death, when they are any money left in that trust will go to the charity that runs the trust. It will not be returned to the family. The pooled income trust with the charity is the only way to protect income for a Medicaid beneficiary over 65 years old who needs to receive home care services but has income above that $879 amount. Those are, that is the completion of the program, although there may be some questions that I'm happy to answer, and I believe that they can be written into the question area. So if I don't see any questions at this point, if anybody would like to write in questions, we can wait to see if any are written in. I thank everybody for their attention, and I'm happy to answer anything I can.
Yes, thank you. So please type in the question in the Q&A. I believe Rosemary raised her hand a little bit earlier. This is your opportunity to actually ask your question. Thank you so much.
So to clarify, Rosemary should type it into the Q&A section.
Correct, yes.
Okay. Can you use the money in your pooled income trust to make a charitable gift? You cannot make gifts out of your pooled income trust. So if your excess income is $1,000 a month, your $1,000 will go into the trust. There is a small administrative fee that goes to the administrator of the trust. And then that money has to be used for the sole benefit of the person who is on government benefits. The only charitable gift that's given is if you have $1,000 each month, and over the course of 6 months you don't spend it all as it accumulates, and then that beneficiary dies, whatever's left in the trust becomes a charitable gift to the charity who runs the trust, but you can't otherwise make charitable gifts. Any other questions? I'll hang on for a few more minutes in case any questions pop up for anyone. I can wait and see if people are forming them, but for anyone who has to jump off, I thank you for listening. And if you do have any questions, this is my contact information on this last slide, and I can be reached if there's any issues, and I would be happy to continue answering. We have another one. Question is, do I have a free consultation? Our usual consultation fee is $350, and it gets applied towards the cost of any work we do. However, for anyone who comes to a seminar of ours, we waive the consultation fee. I guess this counts as a seminar because we're here and we're talking. So if you call and say that you were part of this webinar, and we'll get a list of who was the participants of the webinar, then yes, we'd be happy to offer a free consultation. There was an anonymous question, how much would I charge for a case? It's very hard to say. That's why we when people do come and listen to the explanation for as long as you all sat and listened, we do offer that consultation because it really depends. Every situation is different. So it's very hard to say what I would charge. So unfortunately, I can't answer that question, but I would be happy to speak with or meet with anyone who does have specific questions. It's very, as we went through, but depending on your family situation, depending on your needs and the needs of those who might be your beneficiaries, it's very different from person to person. Okay, we have another question. Can my mother put money in a trust for my sister to use now while she is alive? The money would be used for medical expenses. The answer is likely yes, although as you saw, there are many different types of trusts, and we would have to really parse out what mom's needs are and the benefits to mom as well as for your sister, but I definitely think that it's something worth looking into as part of mom's estate planning to make sure that your sister is properly cared for.
Well, Ms. Burner, thank you so much for presenting this presentation to all of us. We do appreciate it, and thank you for all the information that you've provided.
Oh, you're welcome. Thank you for having me.
And thank you for all the participants that has participated. Please visit our website at pss.usa.org. If you want to visit the events page, you would see all upcoming events that you're more than welcome to participate in. Again, my name is Damon Bradwaite, and I am filling in for Shaina. Thank you all.